You gonna plead to a drunk driver?
Yes, sir.
Oh my gosh.
This is wild already. He's facing a DUI plea and rolls into Zoom court shirtless, with a crying kid in the background. Judges see this as pure disrespect. In real courtrooms, even the smallest sign of arrogance can ruin your case instantly. Would you have held him in contempt right here?
Is your problem? Some clothes on before you come back in here. Get your client together, Mr. Ogletree. Let's go back on the record with Mr. Green. Mr. Green, you indicated you wanted to take the deal. Any objection for having attorney Edward Taylor stand in for your attorney of record, Mr. Ogletree?
No.
State your name, please.
Shamar Green.
All right, Mr. Green, turn your camera on. Can you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, nothing but the truth?
Yes, sir.
You can put your hand down. Do you understand that the maximum possible penalty for this offense is 93 days in jail and or $500 in fines?
Yes.
You understand you have an absolute right to a trial?
Yes.
Mr. Taylor went over your other advice or rights in the breakout room, did he not?
Yes.
You understood those rights?
Yes.
Any questions about those rights?
No.
You know, by taking this deal, you're going to give those rights up?
Yes.
Has anyone offered you anything other than what's been stated in the record?
No.
All right, let me draw your attention back to January 1st, 2024, around 5:52 p.m., city of Detroit, in the area of Kentfield Street, 19015. Did you have an occasion on that day to come in contact with the Detroit Police Department?
Yes.
Were you operating a motor vehicle?
Yes.
Did you have some alcohol before or prior to the operation of that motor vehicle?
Yes.
During or prior to the operation of the motor vehicle?
Yes.
What kind of alcohol did you have, sir?
I had just took a shot of, I think it was Bacardi.
And then how much? How much?
I had literally just took a shot with my dad.
So you took one shot of Bacardi.
And yeah, that's it. That was.
I'm not satisfied, Counselor.
Mr. Green, one shot would not have your breathalyzer that high. Did you have anything else to go with that?
I had something before I took that shot, some wine. That's about it.
Okay.
Well, what is this? What is this, sir? Did you have? I asked you how much you had to drink.
I had wine before that.
How much wine did you have?
I don't remember.
Will you stipulate to the forensic breath alcohol analytical report of a 0.197?
Yes.
Mr.
Yes.
Or a 0.191?
He says he only had one shot. But when your BAC is 0.197, that's around 10 drinks. Claiming just one shot is like saying you only dipped your toes in the ocean while you're drowning in it. Judges know the numbers. This is where his credibility started collapsing fast.
You'll stipulate to that on your client's behalf?
So stipulated, Your Honor.
Did this alcohol impair your ability? Does alcohol affect your ability to properly operate this vehicle, sir?
No.
Yes. Mr. Green, in order to take this plea, you have to state that you were impaired at the time that you got.
No, you know something. I'm not gonna accept the deal. You're sitting here telling the court that you're at a 0.197. And it didn't have any effect on you operating this vehicle?
Yes, I'm sorry.
No, you said no. I
Your
unless
Honor,
he's so,
he probably was confused, Your Honor, because he didn't even remember how much he drank. That's how intoxicated he was, Your Honor.
unless he's so drunk that he doesn't even know that this is, well, let me see what happened, why he got stopped. So were you on the sidewalk, driving on the sidewalk?
Never was I ever driving on the sidewalk.
All right, I'm not gonna accept the deal.
Your Honor, can we have a breakout room?
It says that he, on the PBT was taken, and this is the investigator's report. And it was, at that time, the PBT registered a .208. You may need some, I'm gonna order a substance abuse evaluation as well. You know, put you in a breakout room and speak with him again. Rejoin the room, we'll pass the matter. First line of the report says they called him driving on the sidewalk. I don't know what that means. I'm gonna get the officer in here to give me some explanation if you want to take the deal. Join the room, please. Mr. Ogletree, when you were out, are you there now?
I'm here, Your Honor.
All right, so here's the deal with your client.
And here's the kicker. He backtracks and refuses to plead deal after agreeing to it earlier. In legal terms, that's self-sabotage. The plea was his lifeline, but instead of grabbing it, he cuts the rope himself. Ever seen someone torpedo their own case like this?
He indicates to the court that first and foremost, he started off saying that he only had one shot of Bacardi with his father. And he's got a 0.19 level of intoxication. So unless that shot was the whole half a pint or more, then that's not believable. Then he changes, and in fact, I guess his memory was refreshed for some reason, and he says, "I had some wine too, and I don't know how much wine I had." So we go ahead and start on with the plea. In the police report, it says he's driving on the sidewalk. He said absolutely he's not driving on the sidewalk. And then I asked him, did this affect his ability to drive? He said absolutely not. So I think this matter needs to be set back. I'll give you an opportunity to respond to all that and have the officer come in, and let's see what that officer, the officer in the report is saying a lot different than what he's saying. So what do you have to say about that?
Yeah, I did speak to Sister Counsel earlier when I appeared the first time, and she was saying she wouldn't have objection to a no contest.
Excuse me, for the record, you know what? For the record, Attorney Ogletree, you went and got a deviation from my supervisor. That was not my offer.
No, okay. So I just want to be clear on the record. In terms, I did request deviation, as I told the court the first time, but we did speak, and I asked, would you be okay with a no contest? So I don't know if you're saying you're not okay with a no contest now.
As I informed you, I'd leave that to the discretion of the court. No. If the court wants to take a no contest, I have no problem.
Well, and the thing is that I just feel that Mr. Green is not being totally upfront with the court. That's what I feel he's doing, and not unless he's so intoxicated, which I can believe that at a 0.19.
But a police report says otherwise. Caught on a PBT at .208 and literally on the sidewalk. This is the classic courtroom trap. Deny the obvious, and suddenly every word you say is suspect. When your story shifts this much, even your lawyer can't save you. That he just really didn't have, but I don't like it when it's time to just you're already making a deal and you've got the deal secured, and now it's time to put on the record what you actually did, and he goes totally off and just says, I only had one shot of Bacardi. Mr. Green, do you recall this night?
Yes.
Oh, did I say I asked him, did this alcohol affect his ability to drive? He said no.
Yeah, he informed me that he misspoke when he said that.
How is that? How'd you misspeak, Mr. Green?
Because I said the wrong thing. I guess I didn't mean what I said.
So you lied to me?
No, that's not what no.
Look, Your Honor, he was just.
Wait a minute. How did it affect your ability to drive or not? Or
Yes.
did you believe that it didn't affect your ability to drive?
No, that's not what I was saying.
Do you recall the incident?
Yes.
All right, I'm going to find him guilty as to the operating while intoxicated. I want a substance abuse evaluation. I need a phone number again from you. I know they probably already have it. I'm referring it to probation. You're going to submit to a pre-sentence investigation report and a substance abuse evaluation. What's the phone number again, please?
My number?
Yes. I do recognize that he has passed the test as far as this alcohol test, but I still, with the level of intoxication that he has, with his answers here today, you know, I'm gonna order that test just and for his own benefit, for his age and everything. He's a young man, not even 25 years old or just 25 years old. I'm gonna order that. Sentencing date is going to be.
I didn't hear none of that. Your camera went out. It's disconnected, I guess. There we go. It just fixed.
All right, I'm going to order a substance abuse evaluation based on your age, the level of intoxication that night, and just your answers here today, and just for your own benefit. You're a young man. This is a serious offense, and you know I just want to see what they say as far as that.
The judge flat out says it. So you lied to me. Once a judge uses that word, your credibility is gone. At that point, the only thing left is damage control, and he had none. It's rare to see a judge put it so bluntly, but this one didn't hold back.
Let's set sentencing 45 days out. All right, and I'm going to dismiss the other matters with stipulation of probable cause.
We stipulate to probable cause.
All right, Mr. Green, I'm wishing you the best of luck. I'll see you back on July 23rd.
And
still maintain your sobriety.
Do I continue to drop once a week with the same?
Absolutely. All the other conditions are still in place.
Okay.
And all right, if there's nothing further, sir, best of luck to you. And again, I don't have to tell you about coming in here, laying down with no shirt on. You should be appropriately dressed for court. This is just like you being in the courtroom, even though you get the benefit of sitting at your in the comforts of your own home. All right.
Yes, sir.
All right. If there's nothing further, have a very good day and best of luck to you. All right.